Missouri v. Frye, Supreme Court, 2012. Justice Kennedy delivered the opinion of the court. The Sixth Amendment, applicable to the states by the terms of the 14th Amendment, provides that the accused shall have the assistance of counsel in all criminal prosecutions. The right to counsel is the right to effective assistance of counsel. This case arises in the context of a claimed ineffective assistance that led to the lapse of a prosecution offer of a plea bargain, a proposal that offered terms more lenient than the terms of the guilty plea entered later. The initial question is whether the constitutional right to counsel extends to the negotiation and consideration of plea offers that lapse or are rejected. If there is a right to effective assistance with respect to those offers, a further question is what a defendant must demonstrate in order to show that prejudice resulted from the counsel's deficient performance. Other questions relating to ineffective assistance with respect to plea officers, including the question of proper remedies, are considered in a second case decided today. See Lafleur v. Cooper. 1. In August of 2007, respondent Galen Frye was charged with driving with a revoked license. Frye had been convicted for that offense on 3 other occasions, so the state of Missouri charged him with a Class D felony, which carries a maximum term of imprisonment of 4 years. On November 15th, the prosecutor sent a letter to Frye's counsel offering his choice of 2 plea bargains. The prosecutor first offered to recommend a 3-year sentence if there was a guilty plea to the felony charge, without a recommendation regarding probation, but with a recommendation that Frye serve 10 days in jail as so-called shock time. The second offer was to reduce the charge to a misdemeanor and, if Frye pleaded guilty to it, to recommend a 90-day sentence. The misdemeanor charge of driving with a revoked license carries a maximum term of imprisonment of 1 year. The letter stated both offers would expire on December 28th. Frye's attorney did not advise Frye that the offers had been made. The offers expired. Frye's preliminary hearing was scheduled for July 4th, 2008. On December 30th, 2007, less than a week before the hearing, Frye was again arrested for driving with a revoked license. At the January 4th hearing, Frye waived his right to a preliminary hearing on the charge arising from the August 2007 arrest. He pled not guilty at a subsequent arraignment, but then changed his plea to guilty. There was no underlying plea agreement. The state trial court accepted Frye's guilty plea. The prosecutor recommended a 3-year sentence, made no recommendation regarding probation, and requested 10 days shock time in jail. The trial judge sentenced Frye to 3 years in prison. Frye filed for post-conviction relief in state court. He alleged his counsel's failure to inform him of the prosecution's plea offer denied him the effective assistance of counsel. At an evidentiary hearing, Frye testified he would have entered a guilty plea to the misdemeanor had he known about the offer. 2. Subsection A. It is well settled that the right to effective assistance of counsel applies to all critical stages of the criminal proceedings. Critical stages include arraignments, post-indictment interrogations, post-indictment lineups, and entry of a guilty plea. With respect to the right to effective counsel in plea negotiations, a proper beginning point is to discuss 2 cases from this court considering the role of counsel in advising a client about a plea offer and ensuing guilty plea: Hill v. Lockhart in 1985 and Padilla v. Kentucky in 2010. Hill established that claims of ineffective assistance of counsel in the plea bargain context are governed by the 2-part test set forth in Strickland. In Hill, the decision turned on the second part of the Strickland test. There, a defendant who had entered a guilty plea claimed his counsel had misinformed him of the amount of time he would have to serve before he became eligible for parole. But the defendant had not alleged that, even if adequate advice and assistance had been given, he would have elected to plead not guilty and proceed to trial. Thus, the court found that no prejudice from the inadequate advice had been shown or alleged. In Padilla, the court again discussed the duties of counsel in advising a client with respect to a plea offer that leads to a guilty plea. Padilla held that the guilty plea, based on a plea offer, should be set aside because counsel misinformed the defendant of the immigration consequences of the conviction. In the case now before the court, the state, as petitioner, points out that the legal question presented is different from that in Hill and Padilla. In those cases, the claim was that the prisoner's plea of guilty was invalid because counsel had provided incorrect advice pertinent to the plea. In the instant case, by contrast, the guilty plea that was accepted in the plea proceedings concerning it in court were all based on accurate advice and information from counsel. The challenge is not to the advice pertaining to the plea, but that was accepted, but rather to the course of legal representation that preceded it with respect to the other potential pleas and plea offers. The state urges that there is no right to a plea offer or a plea bargain in any event. It claims that Frye, therefore, was not deprived of any legal benefit to which he was entitled. Under this view, any wrongful or mistaken action of counsel with respect to earlier plea offers is beside the point. The state is correct to point out that, before a guilty plea is entered, the defendant's understanding of the plea and its consequences can be established on the record. This affords the state substantial protection against later claims that the plea was a result of inadequate advice. When a plea offer has lapsed or been rejected, however, no formal court proceedings are involved. Indeed, discussions between client and defense counsel are privileged, so the prosecution has little or no notice if something may be amiss and perhaps no capacity to intervene in any event. And, as noted, the state insists that there is no right to receive a plea offer. For all these reasons, the state contends it is unfair to subject it to the consequences of defense counsel's inadequacies, especially when the opportunities for a full and fair trial, or, as here, for a later guilty plea, albeit on less favorable terms, are preserved. The state's contentions are neither illogical nor without some persuasive force, yet they do not suffice to overcome a simple reality. 97% of federal convictions and 94% of state convictions are the result of guilty pleas. The reality is that plea bargains have become so central to the administration of the criminal justice system that defense counsel have responsibilities in the plea bargain process, responsibilities that must be met to render the adequate assistance of counsel that the Sixth Amendment requires in the criminal process at critical stages. Because ours is, for the most part, a system of pleas, not a system of trials, it is insufficient simply to point to the guarantee of a fair trial as a backstop that inoculates any errors in the pretrial process. To a large extent, horse trading between prosecutor and defense counsel determines who goes to jail and for how long. This is what plea bargaining is. It is not some adjunct to the criminal justice system, it is the criminal justice system. In today's criminal justice system, therefore, the negotiation of a plea bargain, rather than the unfolding of a trial, is almost always the critical point for a defendant. To note the prevalence of plea bargaining is not to criticize it. The potential value to conserve valuable prosecutorial resources for defendants to admit their crimes and receive more favorable terms at sentencing means that a plea agreement can benefit both parties. In order that these benefits can be realized, however, criminal defendants require effective counsel during plea negotiations. Anything less might deny a defendant effective representation by counsel at the only stage when legal aid and advice would help him. Subsection B. The inquiry then becomes how to define the duty and responsibilities of defense counsel in the plea bargain process. This is a difficult question. Bargaining is, by its nature, defined to a substantial degree by personal style. The alternative courses and tactics in negotiation are so individual that it may be neither prudent nor practicable to try to elaborate or define detailed standards for the proper discharge of defense counsel's participation in the process. This presents neither the necessity nor the occasion to define the duties of defense counsel in those respects, however. Here, the question is whether the defense counsel has the duty to communicate the terms of a formal offer to accept a plea on terms and conditions that may result in a lesser sentence, a conviction on lesser charges, or both. This court now holds that, as a general rule, defense counsel has the duty to communicate formal offers from the prosecution to accept a plea on terms and conditions that may be favorable to the accused. Any exceptions to that rule need not be explored here, for the offer was a formal one with a fixed expiration date. When defense counsel allowed the offer to expire without advising the defendant or allowing him to consider it, defense counsel did not render the effective assistance the Constitution requires. Here, defense counsel did not communicate the formal offers to the defendant. As a result of that deficient performance, the offers lapsed. Under Strickland, the question then becomes what, if any, prejudice resulted from the breach of duty. Subsection C. To show prejudice from ineffective assistance of counsel where a plea offer has lapsed or been rejected because of counsel's deficient performance, defendants must demonstrate a reasonable probability that they would have accepted the earlier plea offer had they been afforded effective assistance of counsel. Defendants must also demonstrate a reasonable probability the plea would have been entered without the prosecution canceling it or the trial court refusing to accept it if they had the authority to exercise that discretion under state law. 3. These standards must be applied in the instant case. There appears to be a reasonable probability Frye would have accepted the prosecutor's original offer of a plea bargain if the offer had been communicated to him, because he pleaded guilty to a more serious charge with no promise of a sentencing recommendation from the prosecutor. The Court of Appeals failed, however, to require Frye to show that the first plea offer, if accepted by Frye, would have been adhered to by the prosecution and accepted by the trial court. Whether the prosecution and trial court are required to do so is a matter of state law and is not the place of this court to settle those matters. We remand for the Missouri Court of Appeals to consider these state law questions because they bear on the federal question of Strickland prejudice. If, as the Missouri court stated here, the prosecutor could have canceled the plea agreement, and if Frye fails to show any reasonable probability the prosecutor would have adhered to the agreement, there is no Strickland prejudice.